Hello, everyone. This is Steve Wallace with the Wallace Law Group. I'm going to welcome you to our second episode of Bankruptcy Basics. Today, we're going to talk about if you file bankruptcy, which types of property are exempt and don't count towards the calculation of your available assets. Before we start, I just want to give a disclaimer. This video is solely for the purpose of education. It does not constitute any legal advice by the Wallace Law Group or Stephen Wallace. Let's jump right into it. So today, what we're going to talk about when I'm talking about exemptions, I'm talking about exemptions under Florida law. That is where our law firm is located, and that's the types of clients that we represent in bankruptcy filings. They have to be Florida residents, and we generally only practice in the Southern District of Florida. We are admitted also in the Middle District of Florida. The Southern District of Florida entails Palm Beach, Broward, Miami-Dade, Monroe County, which is Key West, Martin County, and St. Lucie County. Basically, the rest of the populated areas in Florida, the Middle District, we do represent folks under certain circumstances in the Middle District. We are admitted in the Middle District, but for our purposes today, we're going to talk about the Southern District of Florida. I'm going to go through a list of the most popular exemptions that bankruptcy debtors do claim when filing. One of the benefits of filing bankruptcy in Florida is that there is an unlimited homestead exemption, which allows somebody, let's assume you own $1 million home without a mortgage, you could file bankruptcy and all of that equity is exempt. That's an excellent process for debtors in Florida. Additionally, you can exempt $1,000 of equity in your vehicle. If you're a married couple, then it doubles. So you can exempt $2,000 of equity in your vehicle, but that the vehicle has to be titled in both parties' names to take advantage of the $2,000 exemption. Additionally, all of your wages are exempt. So if you're receiving Social Security benefits, those are exempt, and they also don't qualify. They aren't part of the calculation for what your income is. If you have a retirement account, that's exempt. If you have a 529 or any other type of educational benefits for minor children, that's exempt under Florida law. Additionally, if you do not own real estate in Florida, one of the other benefits that you have is you can take advantage of the wild card exemption, which is a $4,000 additional exemption that you can apply against any unexempt assets. And if you're married, that exemption doubles. It's an $8,000 exemption, but you can only use the wild card exemption if you do not own real estate. And additionally, if you have a $1,000 exemption in your furnishings and fixtures in your home, and if you're filing as a married couple, that doubles to $2,000. Now let's talk about some assets that aren't exempt, because that's also important to understand, and that's a factor when we decide what type of bankruptcy generally you file. Because under Chapter 7, any unexempt assets become the property of the bankruptcy estate, and they can seek to sell those unexempt assets or require you as the debtor to pay back that unexempt money to the trustee so you can retain the assets. So any value in any personal property over $1,000 or $2,000 if you're married, that's unexempt. Any equity in a vehicle in excess of $1,000 if you're single or filing without your spouse, and any equity over $2,000 is not exempt. Other things that aren't exempt are lawsuit settlement. So one of the questions that we always ask our potential clients is, are you currently hiring an attorney? Or are you suing anybody for money? That's always an issue that can come into play. And if you file bankruptcy and we aren't aware of that, and then ultimately the trustee finds out, the trustee could keep all of your settlement and pay it off over creditors. And additionally, any settlements, any estate benefits that you receive, or any life insurance proceeds that are received within 6 months of filing of the bankruptcy, we have to let the trustee know. Additionally, if the trustee, if you're filing around tax time and you haven't received your tax return yet, the trustee has a right to claim your tax return. So that's also, again, it's very important to work with a knowledgeable bankruptcy attorney because they can properly advise you on when the right time to file is. With bankruptcy, it's all about working with an experienced attorney. We've represented numerous clients over 10 years in South Florida, and it's important. The timing is very important. And a lot of what we do is counsel our clients to properly file bankruptcy in the right chapter, chapter 7 or chapter 13, and the timing and the plan. Because my goal is when I file a bankruptcy for clients, I want them to be in a much better financial position after the bankruptcy is filed than when they came to me before bankruptcy is filed. Well, I hope you enjoyed today's session, which is episode number 2 of Bankruptcy Basics. Please, if you enjoy, you can search some of our other videos on our YouTube channel, and also please subscribe above to the channel, and look forward to continuing in the coming weeks to educate all of you. Please stay safe, be well, and God bless.